Thanks, Kyle. So my name is Doug Stevens, and I'm one of the chairs of the Boulder Bar's Civil Litigation section. And a few times each year we have what in normal times is an in-person networking and CLE session, and now it's become virtual, at least for the time being. But we are lucky enough to, for the next hour, to hear from Kazi Houston, who will be speaking about using Colorado's new anti-SLAPP law to protect victims of abusive litigation. And she will be in this session talking about Colorado's anti-SLAPP law. She's going to walk through an anti-SLAPP case where the ability of a perpetrator to sue their victim for defamation was successfully blocked by the Rocky Mountain Victim Law Center. You'll hear about challenges implementing the law, challenges with litigating a new law for the first time, and lessons learned in building a strong anti-SLAPP case. And sample pleadings and a list of key cases will be provided to attendees. Kazi is the legal director of the Rocky Mountain Victim Law Center. She obtained her BA and master's from Seattle, and then master's degrees and her JD from DU. And before getting her attending law school, she worked extensively with children and families managing mental illness and developmental disabilities, particularly those involved with the criminal justice system. So I know Kazi handled one of the first cases, or maybe the first anti-SLAPP case in the state. So I think she'll have a lot of useful information for everyone. The goal of these presentations is to be interactive, so please don't be shy about placing your questions in the chat feature, and I'm sure Kazi will get to it. So without further ado, here's Kazi. Thank you so much.
Great. Thank you. Thanks, Doug. Thank you all for having me today. I'm really excited to be able to talk about this case we worked on, talk about how we've used this law in Colorado, and hopefully encourage some of you all to also run with this law and do some really creative litigation with it. I have a little bit of obligatory background about who I am and who Rocky Mountain Victim Law Center is, so I'll start with that, and then we will dive right into content. As Doug said, I'm the legal director at Rocky Mountain Victim Law Center. We are a nonprofit law firm based in Denver that provides services across Colorado. And I'll, on the next slide, switch in a moment to give you an overview of some of our services. I've been at RMVLC for about 4.5 years now. Prior to that, I was a civil litigator doing personal injury cases for 4 years after law school and 2 years while I was in law school. And then before that, I worked as a social worker for 10 years before I went to law school. So I have kind of a broad background, but have a real passion and heart for civil litigation and creative civil litigation, specifically to address victims of crime, and that's the specialty area that we do our work in. I do want to give one caveat early in this training. I am not a defamation attorney, so even though this case that we worked on in our use of the anti-SLAPP law was tied to a defamation case that is not my area of expertise, it was a very niche applicability that we were able to help with in this case. So for broader scope of how this law might apply in other types of defamation cases, I would refer to people who have much greater expertise specific to that area. I also want to very fairly say up front that I've litigated one anti-SLAPP case. However, as Doug mentioned, I think it was the first one in the state. So we did a lot of learning and a lot of work on this case and had to do a lot of work with the judge and consult with a lot of national experts on how we start applying this new law in Colorado, and have been really excited the number of requests we've had for technical assistance and trainings, specifically on how we use the law, how it can be used. And like I said earlier, really hoping to leverage and encourage other people to now run with this law and do some really great creative litigation with it, because I think it has tremendous potential for people in Colorado. A little bit of overview. Rocky Mountain Victim Law Center, as I mentioned, we are a nonprofit law firm located in Denver, but we provide services statewide in Colorado to victims of crime. Our mission is up in the corner on this slide. We do that through a few different programs. One is our Victim Rights Legal Services Program, which is the program we were founded on. And in that program, we represent victims of crime in criminal cases to uphold their rights under the Colorado Victim Rights Act. So we litigate a lot of privacy issues, sequestration issues, really ensure that people who are victims in criminal cases are having their rights upheld, and do some really good creative litigation there. Then we also have a program called LINK, the Legal Information Network of Colorado. that mostly focuses on connecting crime victims to legal information and some services for collateral legal issues related to victimization, lots of housing, protection orders, family law. Through Link, we have a program called Project Attorney Connect, where we contract with private attorneys to do some unbundled and reduced fee representation for folks. So if you're doing private practice, particularly family law or other issues, probate, other things where we often see victim issues come up and are interested in that contract attorney program, feel free to reach out to me, and my contact information is in the slides and will be at the end too. And then we also have a Title IX program where we provide legal services to victims of gender-based violence in school settings, K-12 and higher ed. And then we also do a lot of training and technical assistance like this, and field a lot of questions from civil attorneys and other attorneys in Colorado on and working with a crime victim. You know, what are your thoughts? What have you done with this? How have you addressed these privacy concerns? How do you handle the interplay of the civil case and the criminal case? What ideas do you have? And love to be able to just brainstorm those issues, and always want to be a resource for you all as well. I also want to note that at the end of last year, towards the end of last year, we were excited to launch our Rocky Mountain Victim Lawyers Association, which is a paid membership program that has really high-level specialty CLEs on victim rights related issues. So in all spectrums of law, Title IX, civil law, criminal law, really bringing in good experts nationally and locally to provide some really innovative different types of CLEs. We are doing a full day symposium April 22nd, I believe, that will do really a heavy deep dive focus into victim rights issues in criminal cases. And that is available to reduce cost, and those CLEs are to people that join the association. This is also a major fundraising effort to support the work of Rocky Mountain Victim Law Center. So we are hoping that we can continue to build the capacity of more attorneys in Colorado to work together and collaborate to really do good creative legal work on behalf of crime victims. So I guess I will pause there for a moment. Any initial questions about who we are, what we do, why I'm here today? Otherwise, I will just dive in. But if you have any questions, do put them in the chat box, and I have it open on another screen, so we'll also just keep an eye on it. All right, not seeing any questions, so I will dive right into the content and talk about what is a SLAPP suit in Colorado, what is the anti-SLAPP law, and then how did we use it in a case in Colorado. So a SLAPP suit, for those of you that might not be familiar, SLAPP stands for Strategic Litigation Against Public Participation. This was a term that was originally coined in the late 80s by two professors at DU, and it was really focused originally on suits that were being brought to prevent complaints about environmental crimes and companies against people who spoke out about dumping and other environmental hazards. And then companies would bring a suit against them to try and stop them from being able to speak out, often rooted into defamation suits. So they're suits that are really designed specifically to impinge on someone's right to speech or their right to petition, and are really aimed at trying to stop someone from having a voice, from speaking out about something. And so that's where this SLAPP terminology came from. We have also seen over the years that now, in the kind of context of the cases we work on in our office, is that the suits are also used by perpetrators to sue their victims. So can be done in different ways. Again, like I said, not a defamation expert, so can't speak to the fit if it's speaking out in social media or speaking out to an employer. But in terms of reporting to law enforcement and actually enacting and engaging the legal system on the criminal side, that is where we are often seeing cases that our office can get involved in and use this law. So we know, I'm assuming since you're the civil bar, you all know this, but I like to make sure everyone's starting from the same place. Typically in civil cases, the dismissal of frivolous lawsuits is something that can be done, but it's not usually done until later. It's after some discovery is done. It's after money has been spent, after time has been spent. And in the case of working with people like those folks we work with in our office, after they've been re-traumatized by having to potentially testify, give depositions, go through other processes, have their personal protected health information become part of a case. And then only then can a motion to dismiss be filed, and can you raise that there isn't a legitimate legal case that's been brought. The idea of a SLAPP suit, because it's specifically designed to stop speech and hinder speech, is kind of inherently a frivolous case. So the idea of anti-SLAPP laws is to make sure that you don't have to do this process where you're spending time, you're spending money, you're re-traumatizing people before you can actually try and dispose of the case. There are anti-SLAPP laws right now in the United States in 29 states. Colorado's law went into effect in July of 2019. And it is really designed to be an expedited way of dismissing cases so that you don't have to wait until you do disclosures, you do discovery, you go through some depositions, you re-traumatize people, go through that entire process, spend a lot of money before you can actually demonstrate that a case should be dismissed. The idea is really, this is supposed to be an expedited process. Now, as I talk through, once I get past kind of the basics of an anti-SLAPP law, of the anti-SLAPP law, and talk through our case, you'll see some of the challenges we had with it being an expedited process. But in the way it's written and drafted in Colorado, I think it has great potential once courts are used to using it and we all as litigators are used to using it to really ensure it is truly an expedited process. So as I mentioned, anti-SLAPP laws help prevent costs and delays. They help prevent and protect from invasive discovery processes if a case is really not going to move forward. And most importantly, that I will keep talking about because this is so important as we all take on these cases and try and make good laws, it prevents the person who's been sued, and in our situation, I'll use victim because that's who we work with, the victim in the case from having to testify and go through that process specifically. So Colorado's anti-SLAPP law, the statute is here for you all to reference. It has really strong language in the statute that this law was created by our legislature to encourage participation in matters of public significance. That language is bolded because it becomes one of the legal tests in applying the law and is really relevant. And it's specifically for lawsuits that are filed to limit someone's constitutional right. And it's usually around rights to petition or speech. And the language of the statute and the statutory intent makes it very clear that any effort to try and hinder someone's constitutional rights and their rights to speech and petition is problematic. And so there needs to be laws in place specifically to protect those rights because they're so important. And that is why our state legislature decided to enact an anti-SLAPP law. Our law is pretty closely modeled to the California law, which is kind of the gold standard and where much of the case law that exists is out of California. And is pretty similar to ones around the country and how it's applied. Under the anti-SLAPP statute in Colorado, the very, very broad brush strokes of how a case works is if someone is sued, then they're the defendant in the civil case, and they then have 63 days to file a special motion to dismiss. That's the official term, special motion to dismiss, and say that this is a SLAPP case, this should be dismissed, and this is why. This is why I think it qualifies under the anti-SLAPP statute, and then there should be a hearing set within 28 days of the case. This is the statutory timeline. This is how it's spelled out and how it's supposed to work if everything goes exactly like it's supposed to. Of course, that's not how things usually go. So that's the broad stroke. And then I'm going to spend quite a bit of time on this slide to really talk through what essentially happened in our case and what we learned, what the process is supposed to look like, and what it did look like. So some background context. We were working with a survivor of sexual assault whose offender was arrested and charged with a crime, and his case was bound over through preliminary hearing. So there was a lot of findings that became really relevant in our case. There was a lot of findings that there was probable cause, there was enough to move forward with the case. And then for other reasons, the district attorney decided after the preliminary hearing to dismiss the case and didn't feel that they could prove it beyond a reasonable doubt on the criminal level. At the dismissal hearing, the DA made some amazing findings that were very helpful to us later about how they absolutely believed this happened. They believed our client. They didn't think that she lied about what happened, but they just didn't believe, for the reasons that come up in a lot of sex assault cases, that they could prove it in front of a jury. And so for their ethical obligations as prosecutors, they had to dismiss. After that happened, our client thought the case was done. We weren't working with her at that time. And then she got a letter in the mail that said from an attorney that they were going to sue her for defamation for having reported the sex assault to law enforcement, and sued her for $40,000, I think, initially. Got a letter, and she panicked and started calling people, called the district attorney, and they referred her to our office and said, I think Rocky Mountain Victim Law Center might be able to help with this. We don't really know what the option is. A lot of times when I train on this case and this law, I have the privilege and honor of presenting with our client. I do have some great quotes from her that I added to the end of this slide that I will share with you all because she has some really powerful things to say about this experience and just her experience navigating the legal system that really brings to light just how important this law is. But that's some of the context. So she contacted us and she said, okay, I don't know what to do. I got this letter, someone's threatening to sue me. And she got it in July or maybe June of 2019. So just by chance, because we had some incredible legal interns working on some legislative updates, we even knew that the anti-SLAPP law had passed in Colorado and that it was about to go into effect. So my first step in the case was to write to opposing counsel and say, maybe you don't know, but this new law is about to go into effect in like a week, and we really don't think you're going to be able to move forward with this case. And if you do, I'm going to file a motion to dismiss. So let us know, if you plan to still proceed. They did. So lawsuit was filed against our client. So that's the first step under the statute, that a lawsuit is filed, and then within 63 days, the party who's sued, which defendant in this case, it gets confusing for us because usually defendant means something different in our office. But the defendant, who was our client in this case, then has to file a special motion to dismiss. And in that motion has to plead and make clear that the lawsuit is based on a matter of constitutional right, and that it is a matter of public importance. So there's that initial two-pronged test around constitutionality and matter of public import. So you have to overcome that and really establish that in your initial special motion to dismiss. As soon as the special motion to dismiss is filed, discovery in the case is stayed. There's some tricky things with timelines in Colorado because an answer is due before the special motion to dismiss is due, and initial disclosures are due before the special motion to dismiss is due. So when we looked at our case, we had to figure out, okay, how do we handle this? We know we're going to file this motion, but we also want to preserve the answer deadline. We want to preserve any potential cross claims. We want to make sure we're compliant with discovery obligations. And so we really had to be thoughtful, and I did a lot of consulting with other people. Ultimately, I did file an answer in the case. I did file some really basic initial disclosures, but then throughout all of those, made it very clear the intent to file a special motion to dismiss within the 63 days. In a perfect world, if you kind of have this teed up and ready to go, you could file it certainly before the 63 days, probably before the answer, because this is a brand new law and we're a small office. We had interns scrambling and working to try and work on our motion and get everything ready, but there was a little bit of timing on that. Then under the statute, under the anti-SLAPP statute, discovery should be stayed once the special motion to dismiss has been filed. That was the first issue we had to litigate in our case. I guess I should say technically the first issue we had to litigate is if it was a constitutional issue, but it is. And I have a slide on the key case in Colorado, which is Lawson v. Stow, which establishes that filing a police report is a matter of public interest and is a protected activity. So we had to get through that hurdle. And then we had to litigate discovery and if it should be stayed, and litigate special discovery and requests by the other side to say, under the statute, I get to request special discovery. I get to make sure and see if I need things that actually are necessary for me to address and respond to the motion to dismiss. And so we had to really look at other case law around the country and look at what amount of discovery is legitimate, and at what point does the discovery, is it so extensive that it's essentially denying the motion to dismiss, would be the most concise way I could put it. That if a court says all discovery is allowed, then it's circumventing the purpose of the anti-SLAPP statute in and of itself, and is constructively essentially a denial of the motion. So we had to think about that, and what do we do if the court orders more discovery in the case? And that was another challenge that we faced in our case. Then once you get kind of through those basic hurdles, get the court to say, yes, this is a constitutional issue. Yes, this falls under the anti-SLAPP statute. It is a matter of public importance. Then they set a hearing. And the burden at the hearing is on the plaintiff to show that it would be reasonably likely they will prevail on their underlying case. So in our case, this defamation suit, they had to be able to demonstrate at that hearing that they could prevail. And then we just had to defend that and explain why they couldn't. And then that hearing should be held in 28 days. We filed our case, I think, in August. We had our hearing in May. So it was not within 28 days. It was a very, very slow process. Part of this, just calendar-wise, as you all are well aware at this point, was COVID. So some of it was that we were working on setting hearings, but a lot of the delays were litigating this discovery issue. Then we did a lot of litigation around what does this hearing actually look like? The anti-SLAPP statute specifies that a hearing has to be held, but case law around the state, and we were successfully able to argue it's not an evidentiary hearing. It's really more like a status conference, it's a motions hearing essentially. But we really had to litigate that and grapple with that. We had, other issues along the way of Are we allowing witnesses? Are we deposing witnesses? What's coming in on this? And so I had to litigate all those issues. And then kind of as we got to the point of, okay, this is resolved, we're ready to set it for a hearing, then the court shut down and we were wildly delayed. So we also had the privilege not only of being perhaps the first in the state to litigate this case, the first hearing that we had remotely with this judge was his first remote hearing, which had its own challenges that, you know, now a year into this, we all know that the courts are doing an amazing job with remote hearings and with WebEx, but it's a lot of fun when we talk to our client about this and she gets to talk about just what that experience was like with the first remote hearing that a court had ever held, and some of the issues with feedback and just technology and the logistics and how do you show exhibits. So as you all know, and I know you can all relate to as well, that was an added challenge that we faced in this case, just based on when the timing fell and when the hearing happened. But essentially, we had a hearing. The plaintiff tried to establish that they had enough to go forward, that their case was legitimate. We were able to make some really good arguments specifically around the fact that charges had been filed, probable cause had been determined. There'd been a civil protection order entered, which also had a higher burden than this case had to prove. It had been bound over from a preliminary hearing, so there'd been a finding, there was enough evidence to move forward. And there was some stuff that happened in our case with alibi witnesses that were kind of found to be somewhat incredible on the back end of the case, and some factual things that were kind of unique to the case. I will say, and I'll note this again when I talk about the materials that I will provide for you all, our case is sealed because of the content of it and the fact that it's a sex assault case. So you won't be able to go pull it and look at it. But I do have some redacted pleadings from it to share with you all because of that. But there were also just some unique facts in our case too that it made it identifiable. So that was the other reason we wanted to make sure that we suppressed it. And but I'm always excited to share the experience and the factual or the legal arguments that we made, even if the factual basis is really identifiable. The other things that then happened, so then we had the hearing. We had a great judge throughout this case that did a lot of work on researching anti-SLAPP throughout the entire process. We had multiple status conference calls. He repeatedly asked for lists of cases, sometimes asked us to brief things additionally, and we really had to figure out, okay, we have this new law. How is this actually working? And how do we work with the timelines? And what does it mean, no discovery? Does that actually mean no discovery? And what is this hearing? And how should this look? So we did a lot of work around that, did a lot of litigation, had the hearing. Ultimately won. A week later, we got the order that said that our motion had been granted, the case would be dismissed. And then with that came a really nice attorney fee award. So one of the neatest things that's helpful, I think, for civil litigators with the anti-SLAPP law is that there is a really, really strong cost and attorney fee provision that if the case is dismissed and you win it, they just get awarded. It's not discretionary, it's not optional. You have to, obviously do your bill of costs and everything and justify it, but it does provide a really good remedy on the back end to make sure there's an incentive for people to take these cases, and ultimately was helpful. We have a nice attorney fee award that we may or may not ever be able to collect on, but it's out there, and I think that's a really, really helpful element too. So that's kind of the broad overview of the SLAPP process and how it looked in our case. This is the case that I'd mentioned, Lawson versus Stow, which specifically speaks to the fact that police reports are protected matters and they are matters of public concern. This was the entire case on the state level that was really at the core of our success with the anti-SLAPP statute, to be able to say, yeah, if you report a crime, there's a public interest in making sure that people who are victimized or witness crimes have an incentive to report. It should be a protected activity. And if someone is being sued because of that, because they spoke out and reported a crime, they shouldn't have to go through that. That's kind of an inherently frivolous act. It falls under SLAPP, and the anti-SLAPP statute applies. So even though this case was several years predated the anti-SLAPP statute, it is particularly relevant in this particular situation where people have reported a crime and then been sued for it. I can tell you that since we brought this case, we get regular calls from people who are referred to our office with a similar situation. As I mentioned, we're not sure how well it would work if it was not that I reported a crime to law enforcement, but I reported to my employer or I posted it on social media. Those wouldn't be as clearly constitutionally protected, but in this very narrow scope of someone who's reported a crime to law enforcement, it is protected, and this is the key case. So I'm going to talk a little bit about lessons that we learned in litigating this. I mentioned some of this already. I'm going to share some of the things that our client has shared on the impact this case had on her. And then I would love to answer any questions you have after that. So, and I'm looking at the clock, realizing I've been talking really fast and I'm way ahead of time. So you might get some time back today in your schedule. So lessons that we learned were both from using the anti-SLAPP statute and just litigating a new law and taking a brand new law that the judge had never seen. That was the first thing he said at our first conference is, I haven't seen one of these. None of my colleagues have seen one of these. We're not really sure what to do with this case. So the very kind of fundamental, these are not big, bold and innovative lessons, but they're important ones to keep learning and remembering as attorneys. It's just read and reread the statute. I was back in that statute all the time. I had it printed out on my desk. I had notes all over it. I had it all over my computer. All my interns had it. A lot of the other folks on our team had it, and constantly just referencing back to, if the only thing we have is this statute, there's zero case law related to this law in Colorado, then the statute is everything. We have to really make sure we're really looking at it, and we're looking at the legislative intent, and we're looking at the purpose and the language, and if it cross refers to other statutes, making sure we pulled those and figured out the timing and the rules of civil procedure, and just constantly going back and checking the actual statute. I think when we litigate similar issues all the time, we don't always go back and pull the statute book and or look it up and print it out and go back to those basic statutory language. But it was really, really key in this case because it was really all we had. The other thing I would say is, I mentioned if there was something I could fix in this law, it would be the timeline issue with when answers are due, when discovery and initial disclosure starts, and then the fact that the motion to dismiss isn't due until 63 days into the case. That was just complicated. It just became a messy process. And I've definitely gotten calls from attorneys who have said, did you file an answer? Did you file the motion with your answer? How did you do this? And we just kind of punted, we guessed. We are not, by our funding, allowed to do tort cases in our office. This was more of a defense case, not for money. So we had to be careful to file an answer where we would preserve the right for our client to potentially pursue a cross claim later, but also knowing if that happened, we couldn't represent her. So I did a lot of consultation with people on our board, other partners of, how can I craft this answer to preserve that cross claim, knowing that our goal is ultimately to get this case dismissed. Probably not an issue for anyone else who doesn't have the wonky funding limitations that we do as a nonprofit. But those were also issues for us in the timeline and the deadline. And then just really making sure that we were filing that initial special motion to dismiss in a way that addressed the statute, brought in case law from other states, figured out how we needed to, how we drafted it all. It takes a lot longer to draft things when it's new law and there's nothing else to look at and no other examples out there. So the timelines and deadlines were there. Judicial education was huge in our case. So very, very early on, when I first filed the answer and said we plan to file this anti-SLAPP suit, the judge immediately filed an order that said this is not a constitutional issue. And I don't think we even knew Lawson v. Stow at that point was kind of the key case. We were focused on some other aspects of the statute, and we're diving in and working on it, and really had to start from that ground basic point of, okay, you already are saying don't even bother filing this motion to dismiss. I don't think filing a report with law enforcement is a protected activity. So we had to then go back and address that. I do have some of our redacted pleadings that I'm sharing with you all, but because it wasn't a clean case from A to Z, they're not great pleadings to copy. They're useful in terms of the case law, some of the arguments that were made. Someday I will task an intern, or I will do another one of these cases and make a really good clean set of things that incorporates everything we learned over the 9 months of litigating this case. But that was one of the first things we had to overcome. So we made sure when we did our special motion to dismiss to really beef up and talk specifically about the constitutional protections of filing a report with law enforcement and reporting a crime. So we did a lot of judicial education on that. We had an amazing judge who was literally spending his weekends doing research on this case and was saying, hey, I'm going to work on this all weekend. So by Friday afternoon, just send me a list of citations. And I only have Westlaw, not Lexis. So send me those ones, or whichever his preference was, and was very specific on, I don't want briefings. I don't want summaries. Just, here's my email address. Send me a list of the cases. So we had a judge that was willing to do the work and do the research, which was really helpful and really open to that. And it was a bit of a trade-off because it did slow down the process, but he was thoughtful and he did a great job of making sure that he was reading the other laws and the other jurisdictions that have had these laws for longer than us. So with a new case, the judicial education piece proved to be just huge, and that took a lot of extra time that we didn't expect, but had a huge payoff in the end of having a great judge that was presiding over the case. The other thing that I would say was absolutely fundamental to us was looking to other jurisdictions and experts. So as I mentioned, California has kind of the gold standard in anti-SLAPP laws. Even though the coin was termed out of Colorado, it's very new here. But California has tons of case law. They've had their statute long enough that they've modified it to address and respond to case law. There is an amazing treatise that's on a list of resources and key cases that I have for you all too, that really addresses some of the anti-SLAPP focuses. A lot of the cases, the treatise is by a gentleman named Thomas Burke, who I talked to and worked with quite a bit while we were working on our case, and was a great resource. They do a lot at his firm, a lot of First Amendment cases and media rights cases. So their SLAPP cases don't often fall in the realm of sex assault victims sued for defamation, but it was all very applicable. So really getting to learn from him and from some other experts in Oregon and some other states of what does this look like? And where that became particularly important, more so than anywhere else, was the hearing, is that we had no idea what this hearing was supposed to look like. We were reading cases from all over the country to try and glean what does this hearing look like, and having to kind of read between the lines. There was no one that said, there are witnesses, there are no witnesses, there was no published opinions anywhere about it. And so I had to talk to people who actually do these cases in other states, and worked on our networks until we found people that actually knew them and had done anti-SLAPP cases, and every single one of them said, oh, please don't ever let a witness be called at your hearing. This is very, very important. You will make bad law, you will hurt us all. These are not evidentiary hearings. And then really helped me find the law to back that up and to support that. So that was a huge, huge issue we litigated in this case, and would be, I would say, the number one takeaway I would ask that everyone takes from this today is that if you litigate these cases, please don't have an evidentiary hearing. This was another point where, in working with Tom Burke and other folks, where he was saying, if you have a hearing, that's essentially a denial of your motion. You need to appeal it immediately. There is also a really good appeals provision. We didn't have to appeal ours. The other side didn't appeal, so we didn't have to go that far. The anti-SLAPP law does also have a very specific and very clear appellate process. So you can appeal right away. I expect a lot of these cases will be appealed. If you work on these and you get appeals, we would love to help and do amicus support if it makes sense, if there's any tie to victim issues. It's something our office is definitely keeping our eyes out for. But specifically, this issue of an evidentiary hearing is a really big one that only other practitioners from around the country could affirmatively say, no, these hearings do not have witnesses. You might present exhibits, but they're not exhibits based on discovery. It's essentially what was pled in the initial part, unless there's some really limited discovery ordered. And absolutely, it is not an evidentiary hearing. Otherwise, you're effectively litigating the defamation suit, which is a constructive denial of the anti-SLAPP motion. So that was really helpful. That was the biggest hurdle, the most challenging thing to figure out. And it was absolutely dependent on connecting with the experts around the country that could really give me some good guidance. Similar to that, what I just said around make good law. When you're working on a new law, make sure you're making good law, talking to other people around, what do we need to be careful for here? What do we need to watch out for? One of the things we dealt with in our case was trying to figure out if we wanted to try and settle. And had to put our clients' interests at the forefront, and that was the number one priority for us. But also looking at, okay, well, what could happen if we settle this? If we don't litigate this all the way through, could there be adverse consequences? And for our client, it made sense at one point to offer to settle, to say, we won't pursue attorney's fees if you dismiss this whole thing because we really think we're going to win. They rejected that offer. We also got an offer from the plaintiff in the case at one point requesting a public apology, which we rejected. So there was, some different things along the line, but part of that, in addition to just normal settlement conversations and normal conferrals with clients, was really thinking about what will the impact be if we make this decision. If we offer to walk away from attorney's fees, could that harm other people in future cases? It was vitally important to our client that we make good law. She was very aware that this not only helped her personally, but that it could be really transformative for other victims and other people in Colorado. So we had a lot of really good conversations about that in the strategy as we went along. The other thing I would say is just being brave. As I mentioned, I was a civil litigator before I came to Rocky Mountain Victim Law Center. We, as an organization litigating victim rights issues, are often dealing in novel legal arguments. this was a really hard one. This was a really brand new one. It was hard to find the other state precedent. It was hard to deal with the process and procedure to do the judicial education. Factually, it was a hard case. It was hard for a client, but it was worth it. And it did a lot to advance and really show how just powerful and amazing this law can be in Colorado. So I would encourage everyone to be brave and take these cases, especially knowing about the attorney fees. So I wanted to just pause and share some of the amazing things that our client said about this case. And I will read through these a little bit. If she was reading them, we'd probably all cry. And it was a really powerful experience for her. And I think we think about creative litigation and we think about new laws and how can we leverage this and how can we get fees and what are we doing? But at the core of it, there's someone who has been, wounded by the legal system. There's really no other way to put it. That someone has filed a lawsuit, used the legal system to try and further victimize someone. And in our case, it was, one of the worst kinds of victimization that people can experience. So when we talked to our client and said, what was that like when you got this letter in the mail that said you were going to be sued? That's the first quote on here is, I thought this was over, that I would never have to see his name or face again. And then I was just in utter shock. And she talked about how she sat in her car and she cried. And she just come back from vacation and picked up the mail and thought, I've gotten all this legal mail in a criminal case, but that's done. What is this legal mail? And had no idea this was even a possibility. No one ever told her it was possible that her perpetrator might sue her. And it just totally caught her off guard. And then when we talked to her, when we presented with her in the past, talked about, what was that like when we finally connected with you? And she said, everyone else I called said they couldn't help. They said there was nothing they can do. And then when she, meaning me, said, we can help you, I cried. She cried a lot. Or she did at that time, at that point, and has been through a really hard situation. And just that agony of how she talked about it and talks about it to people of, I thought this was done. Like the criminal system failed me. I didn't get justice there. I thought it was done. I was working on moving on with my life. And then I got this letter and it just further devastated me. And then I asked people for help and everyone said they couldn't help me. And then so finally, when someone was willing to be brave and take on this case, what that meant for me. And what she added to that was someone was finally going to protect me. The law was finally going to protect me. And I think we hear all too often with the folks that our office works with how much they don't feel like the law protects them. And I think it's particularly important to recognize this statute is so special because it does provide a really strong and valid protection to victims and other people who are having the legal system used to cause them more harm. Another great thing that she said is that, the judicial system makes you want to run away. It makes you wish you never told the truth and that you just dealt with it all on your own. Unfortunately, this is another thing we hear from a lot of folks we work with. I wish I'd never reported. I wish I'd never even pursued anything. I didn't think, I thought the legal system would have a remedy, that it would protect me, that there would be some good outcome. And if I knew it was going to be like this, I never would have reported. And then to add to that, she said, when people tell their truth, it's hard. The anti-SLAPP law protects you with your First Amendment rights to go to the police. This law was critical in protecting me for telling the truth. And that's really fundamentally what this law is. People that are brave enough to come forward and speak out, whether it's an environmental harm, whether it's a sex assault, whether it's another crime. There's a lot of cases out of California related to pretty horrific child abuse cases where the anti-SLAPP law has been applied. People that are brave enough to speak out and tell their truth have the right to have that truth protected and have a law that says, that's right, you did the right thing, you spoke out, and you can't be harmed for that now. And so it's really fundamentally why it's important. And then I love that at the end, she's talked about when the cases ended, that after this, because this case was dismissed, I could get back to my life. I was able to enjoy my days more. It was finally over. And it was a big deal to her to have this go away. And after we actually got the final order to dismiss this case on the 2-year anniversary of the date of the sex assault, just randomly, it happened to time out that way. So 2 years of her life was spent on this case, going through the criminal process, then being sued, then going through this case, really struggling with the uncertainty of litigating a new type of law. A lot of the conversations we had to have around, we don't know what's going to happen. We don't know what the judge is going to do. We don't have anyone else who can tell us what this should look like. We are just guessing and really writing it out with us, not only in the greater good for herself, but also for everyone else in Colorado. So it was truly, like I said, an honor to be able to work with. Resources that you are going to get There is a list of some key cases and resources, including the treatise from Tom Burke. The citation for that is in there. There are redacted versions of my original motion to dismiss and an objection that was the objection to the witness and exhibit list, but it was really the objection to a hearing. So that's where a lot of the good case law and everything around the hearing is there. And then there is a redacted version of the final order in the case. It's heavily redacted because of the facts of the case and needing to preserve the privacy of our client. It is also redacted by me in my basement with a Sharpie because it was a PDF, and because we're a nonprofit, that's how we have to do things. So I apologize for the sloppiness of that. If you would like to support our work, I will make the obligatory plug. Please join our Lawyers Association, come to our paid CLEs and things like that so that we can actually get things like Adobe Pro and redact orders in a dignified way. So that is my standard nonprofit plug for you all. And with that, I have my chat box open and I'm happy to answer any questions that anyone has or hear about anything that you all are doing with this law. Not a single question. Have any of you that are on this had an anti-SLAPP case? Have you started litigating one at all? You can also unmute. It's a small enough group. Oh, there we go. I have one on appeal. Oh, great. Someone has one on appeal.
Hi, Kazi. This is Byung-suk. Since we're in a small group, I figured I just, and I'm a slow typer, I figured I just asked the question. Did you actually proceed, and I'm the individual who has the one on appeal right now. We succeeded and obtained a motion to dismiss, and we just submitted our answer brief because the plaintiff in the case, the husband, and we represent the wife. But did you proceed and actually finish a hearing on attorney's fees and get that granted? And if so, I was just wondering, my experience with attorney's fees hearings, you always get a haircut at, and I was wondering what kind of haircut you may have gotten.
They didn't challenge them. So we didn't have a hearing. I submitted the motion for attorney's fees. I believe the plaintiff in the case might have run out of money, which is also why they didn't appeal. So they didn't contest our attorney's fees. The challenge we have is that we're a nonprofit and all our services are free. So we had, in this case and another case, worked with some of our great partners who do civil litigation specifically with victims to do some affidavits to establish reasonable rates. And because it was mainly me and unpaid interns doing the work, our attorney's fees felt very sizable to us in our office. I think they ended up being around $30,000. But I think in the broad scheme of things for large firms and things like that, and if there's exhibits and anything else done, it's different. So we were in a unique situation with that, but we didn't have a hearing. I thought we would have, but oddly enough, he did not challenge the attorney's fees.
Thank you. One more question. You said your entity would be willing to participate in amici briefings. Would you be willing, if this at the Colorado Supreme Court level, or do you prefer at the Court of Appeals level? I'm assuming it's still that first.
We'd look at it either way. I think this is a law that has kind of worked its way into the hearts of everyone in our organization, and we think it's important. So yeah, if the case you're working on has any tie to victimization at all, absolutely reach out to me, and I would love to talk about if it's something that we would want to do something.
Great, thank you.
Yeah, absolutely. And then I saw a comment in here asking about Rule 11 sanctions only, and that the law doesn't appear to protect one private citizen from another from abusing the court process. I don't know that I fully understand. If you want to unmute and kind of elaborate on the thought on that.
Well, yeah, this is Ed Byrne. There are certainly circumstances where it feels like a private citizen is trying to overwhelm another private citizen in the context of, I have a land use case where that seems to be happening. But it isn't the exercise of a protected governmental right to participate in the petitioning for redress of grievance. So I'm guessing that this doesn't really apply. It doesn't seem to meet the definition.
It would have to be, yeah, okay, now I understand, thank you. It would have to be something that triggered a constitutional right that was also a matter of public interest. So that's where that, like, not being a general defamation attorney, I don't know where it would fit, but it has to be, it's usually used around speech and petition. It's where it's mainly seen, but I also think there's a lot of constitutional rights, and I think a lot of things could be tried to fall under this.
Okay.
But generally, I think it works well if it's really established, like reporting a crime to the police is absolutely very clearly protected activity. And I think other things might not be as clear.
Thank you.
Kazi, this is Byung-Suk again. If I could just add to Ed's question, I actually think the statute itself, it's pretty short. And if you look at the examples on which they say falls within the First Amendment rights to petition as well as free speech, it's far broader than I ever expected. And so it could be applied between two private citizens, I think, in my opinion. If one citizen just starts announcing something of public concern and has a press conference saying, hey, this company A is doing something which I think is illegal or something of public concern, the issue in our case turned on that, which was two private citizens, and the constitutional right determination hinged on whether the speech and the petition involved an issue of public concern.
Yeah, and as I mentioned kind of at the beginning, the SLAPP case designation really came out of environmental lawsuits and people speaking out about toxic dumping and of other environmental harms, and then companies trying to shut them down. But our case also was between two private citizens. It was, you know, the sex assault survivor and the perpetrator. So there was no government entity involved other than in as much as he'd been arrested at some point. So the report was made to the government, and that made it more protected. But I think it can be used really creatively, and I think if you have the means to take on cases that might not win, I think I would love to see this law, you know, stretched and expanded in a lot of ways. I do also see the question about the court file. It's suppressed. I think it's suppressed and not sealed. It was in the 18th, and I don't remember the judge's name, but it might be in the order that I send you all. I'm not great with remembering names, so but it was out of the 18th. And I know by the time our case wrapped up, he had another one sitting on his desk. I think it was very fast moving once people started to use it. The other question I see in here is, does the law apply to victims of harassment who are not victims of crime? Thinking about people who've been threatened by counsel not to go to the authorities. I think it could. That would be that kind of defamation expertise thing. It's often brought as a defamation case, and I don't know, it would have to be protected. And I think because of the employment protections that can exist, I think you could probably make an argument that there's constitutional rights or protections that are, it's an effort to prevent that. By filing the lawsuit, the entire whole kind of point of a SLAPP suit is to try and stop someone from being able to speak out. So if that's happening, I think if you can make the argument that it is a constitutional issue and it is a matter of public importance, then I think you can get there. I think it's harder. You know, I think we kind of had this dream case dropped in our laps where we had an arrest, we had case bound over at a preliminary hearing. And so it already also, we did a lot of arguing around precedent, and the judge in our case, you know, even in one of our status conferences, asked plaintiff's attorney, are you asking me to overturn the decision of the criminal court and finding that this case had enough evidence? And it was at that point that we then extend our settlement offer. Said, you know, I think the judge has made it clear that the criminal court found there's enough evidence, so you're gonna lose. So, you know, that was really helpful and made it cleaner. I do think it can be used in other contexts. And I think in employment harassment and other harassment situations, it would be a great place to really test it out and see the full expanse of it. Great question. Any other questions or thoughts from anyone? All right, and that brings it almost to the hour, so not bad.
Yeah, thanks. Thanks, Kazi. Thanks everyone for attending. We're at 50 minutes, so we've certainly satisfied our the necessity to get the CLE credit to 50 minutes. But yeah, as Kazi mentioned, she'll be or will be sending out the materials from today. And thank you so much for a very informative presentation and for all the questions and everything. So really appreciate it.
You're welcome. Thank you all for coming, and really do please feel free to reach out. I love talking about these cases, and I'm super excited to hear what other people are doing with them. So feel free to reach out anytime.
Thank you, Kazi.
Thank you.